Hi, my name is Abu Bakr Siddiq Yusuf Jalal. My student ID of the University of Hertfordshire is 230973999. In this video presentation, I'll try to articulate whether AI tools like Gemini have potential bias, misinformation, or hallucinations and ethical implications while answering questions. And I will also try to critically analyze the AI generated answers from Gemini in the field of intellectual property law. I've chosen to give feedback to Gemini's answer on Getty Images US against Stability AI. In the AI answer from Google Gemini, the explanation of the US perspective is not correctly described according to my understanding. First, I find that Gemini's answers about the Lanham Act are improperly described. It didn't mention what the Lanham Act actually protects, but it only says what the court will consider. In the case of Getty Images and Stability AI, the fact is whether Stability AI constituted trademark infringement according to the Lanham Act. To find the actual answer, Gemini had to describe the Lanham Act action and definition, which it didn't. It would be better if the answer would mention what the Act actually establishes. But the Gemini answer didn't mention that way about the Lanham Act. And that's why I find it could be explained better. The second issue in the answer is it didn't bring enough relevant sources like primary and secondary sources of law. It could be even better, and the US perspective part has been also explained very briefly and didn't bring some famous cases in the US regarding trademark law infringement to prove it more relevant. It could bring some instances using cases like Qualitex Company against Jacobson Products Company, where Qualitex Company used a distinct shade of green gold color, the dry cleaning process press paints it produces. Although Qualitex initially prevailed in district court, the Ninth Circuit overturned the ruling regarding trademark infringement, stating that the 1946 Trademark Lanham Act does not allow colors to be registered as trademarks by themselves. And another case of trademark infringement of AMF Inc. against Slickcraft Boats, 1979, could be discussed as well, where the district court conducted a short non-jury trial and determined that the trademark of the appellant AMF was valid. It was not infringed upon, leading to the denial of AMF's request for an injunction. The district judge concluded that confusion was unlikely. So, in the Google Gemini's answer, the relevant case laws, like I mentioned, would make the Gemini's answer more competent and successful, according to my understanding. That's another shortcoming of AI. Now, the other disagreement with the Gemini's answer is that it hasn't described UK perspective clearly as well. It didn't use relevant case laws and relevant sections of UK Trademark Act 1994 to justify the situation of Getty Images case. It could describe the Trademarks Act 1994. A registered trademark is considered infringed if an individual uses a sign in trade that is identical to the trademark for goods or services that are the same as those for which the trademark is registered. The answer could highlight that and use some relevant cases like Arsenal Football Club PLC and Matthew Reid, in which they alleged that Mr. Reid had infringed certain of their registered trademarks to argue the issue better. Another UK case like Irvine and Ors and Talksport Limited, where Eddie Irvine, a prominent racing driver, along with some of his management companies, initiated a passing off lawsuit against Talksports Limited, TSL, where Judge Lady ordered TSL to pay Mr. Irvine $2,000 in damages for passing off, plus interest. So this kind of relevant cases instances could make the answer more relevant. But the lack of these made the answer incomplete and proved the shortcomings of AI answers. Gemini answer had biasness and hallucination as well. It seemed like the Gemini indirectly favored Getty images, showing the possibility of achieving injunctive relief and damages by Getty in the judgment. AI bias is known as machine learning bias or algorithm bias, refers to the presence of skewed results stemming from human prejudices that affect the initial training data or AI algorithms. This can result in inaccurate outputs and possibly negative consequences. So in the Gemini answer of the Getty and stability case, the indirect bias of Gemini towards Getty is noticed as Gemini answers without proving stability AI's trademark infringement with a proper explanation. It just said that the possibility of Getty's achieving injunctive relief and damage is high. How can Gemini give a verdict without proving the argument with relevant case laws? So the information in Gemini neither accurately described nor unbiased. Additionally, the writings were not logically structured and it had lack of primary and secondary sources of law as well. AI errors can be very unfair because of bias leading to certain groups being denied opportunities, misidentified in images, or unfairly penalized. The organization responsible face damages to its brand and reputation. Meanwhile, the affected individuals and society at large may endure negative consequences without even being aware of them. AI bias can be negatively impactful in the real world. Some notable instances of bias and disparities in AI and the resulting harm they can inflict are mentioned here to support my argument. In the healthcare sector, a lack of representation of women and minority groups can lead to biased predictive AI algorithms. For instance, research has shown that computer-aided diagnosis systems often yield less accurate results for African American patients compared to white patients. While AI technologies can enhance the efficiency of resume screening to pinpoint suitable candidates, the type of information requested and the criteria used for evaluation can lead to imbalanced results among different demographic groups. For instance, using the term ninja in a job advertisement may attract a higher number of male applicants despite not being a necessary qualification. The types of AI bias are cognitive bias, confirmation bias, exclusion bias, measurement bias, stereotyping bias, etc. And the AI has lack of understanding too. AI's response lack of deep analysis demonstration of the legal issues due to lack of algorithmic transparency. The issue of algorithmic transparency is a critical concern in the current legal discourse surrounding AI. According to Cath 2018, as AI technology expands into high-risk fields, there is increasing pressure to ensure that AI systems are designed and governed in a way that promotes accountability, fairness, and transparency. The absence of algorithmic transparency is problematic, as highlighted by Desai and Kroll 2017. There are instances where individuals have been denied jobs or loans, have been placed on no-fly lists, or have had benefits denied without understanding the reasons, aside from the fact that these decisions were made by software. Moreover, the information regarding how algorithms operate is often deliberately hard to access, which worsens the issue. My recommendation regarding AI and trademark infringement in legal issues would be: trademark infringement and AI need for re-evaluation and fundamental principle. The swift advancement of AI technologies has created a necessity to reassess certain fundamental principles and practice of trademark law. One prominent element of these advancements is the application of AI in trademark applications, registrations, and related administrative tasks. According to the index released by the World Intellectual Property Organization, WIPO, patent offices internationally are implementing these technologies to enhance transaction efficiency, accuracy, and overall productivity. Specific instances of AI usage in trademark application and registration include conducting comparative similarity assessments, searching databases for previously registered similar trademarks for clearance, and automating certain office processes. Another important factor is the evaluation of AI technologies in relation to the existing principles of trademark law. A key role of trademarks is to identify the origin of goods and services for consumers, distinguishing one business from another. The assessment takes into account the average consumer. Average consumer defined as someone who is reasonably well informed and observant. Given the fast-paced nature of modern shopping, the hypothetical average consumer often lacks the time or ability to compare products and tends to rely on their memory of an image or impression. This assumption of imperfect human recollection forms the basis for determining the similarity, the likelihood of confusion, and potential infringement. Another concern is that instances of trademark infringement arising from the use of these technologies, it remains uncertain who should be held accountable in what manner. So trademark owners must carefully observe the opportunities presented by this growing technology as they shape their business strategies and take proactive steps to prevent potential infringement issues by strictly following sections of the Trademark Act 1994 as well. Finally, I'd like to conclude by saying that AI plays a vital role in significant sectors, including legal sectors as well, but there is nothing that can substitute human touch. I believe that AI is appropriate to assist to some extent, but not to replace. We can use AI as a useful servant, but not a dangerous master. Thank you.